everyone. Welcome to our keynote address on arbitration in India here at the SKOCH India Law Forum and LITFest 2022, organized under the aegis of the 82nd SKOCH Summit. Today we're joined by Mr. Sameer Kochar, Chairman of the SKOCH Group, and our honored guest, Dr. Lalit Bhasin, Managing Partner of Bhasin & Co. and former President of the Bar Association of India, and Dr. M. Ramachandran, Distinguished Fellow of the SKOCH Development Foundation, former Secretary, Government of India, and a SKOCH awardee. Though Dr. Bhasin and Dr. Ramachandran need no introduction, it is still my pleasure to share a little bit about them with all of you and invite them to today's conference. Dr. Bhasin established his law practice in 1962, and in the time since, Bhasin & Co. has come to be recognized as one of the largest law firms in India. Dr. Bhasin has been instrumental in shaping the legal landscape in India, having served in many leadership roles through the decades. He has served as the President of the Bar Association of India, the Chairman of the Delhi Bar Council, President of the Society of Indian Law Firms, Chairman of the Chartered Institute of Arbitration India, President of the Inter-Pacific Bar Association, and National Vice President of the Indo-American Chambers of Commerce. In 2002, he was awarded the Plaque of Honor by the Prime Minister of India for serving the rule of law. In 2007, the President of India conferred upon him the National Law Day Award for outstanding contribution to the development of the legal profession in India and for his deep involvement and engagement in the maintenance of the highest standards of the bar. To say that the legal profession in India as well as internationally are in debt to Dr. Bhasin would be a gross understatement. Dr. M. Ramachandran has served as the Secretary of Urban Development and played a pivotal role in the implementation of many critical city reforms projects and programs like the Jawaharlal Nehru Urban Renewal Mission. As Chief Secretary, Uttaranchal, he came to be known as the infrastructure man because he undertook several important public-private partnership projects, ensuring $1 billion in assistance from the Asian Development Bank for the power, road, and urban sectors, as well as securing $120 million from the World Bank to augment the drinking water sector. I'd like to now invite Mr. Kochar, author and chairman, SKOCH Group, to share a few words and open today's conference.
Namaskar. It is indeed my pleasure to have two very important people, the law man of India and the infrastructure man of India together in this conference on India Law Forum, which is on intersection of life and law. As you know, my work essentially is on socio-economic development of India. And if you look at socio-economic development, currently the waters are looking very choppy. From 2017 to 2020 period, our average GDP growth rate has been 5.7%. Moving forward, the projection is about 7.2%. So therefore, the target of 5 trillion economy by 2025, as envisaged by the Honorable Prime Minister, will be quite short. It will be short almost by over $1 trillion. So that's a deep cause for concern. On the other hand, if you look at gross fixed capital formation, it's been falling. It's less than 30%. And incremental capital to output ratio is moving towards more inefficient. From 3.5 in 2016, it has moved to 5, which tells us that the Indian economy is becoming more and more inefficient. If you look at the last budget, there is a lot of focus on infrastructure and big spending is expected there. And the biggest challenge, as articulated even by the Honorable Mr. Gadkari, is the cost and time overruns and how do you shave off cost of logistics. So within that comes the ambit of, the arbitration, the legal system. I mean, we are a fairly litigative society. Government of India is the biggest litigant. And that creates a challenge for practically every contractor that they have. To handle that litigation load, an alternative system of arbitration was envisaged quite a few years back. Has that taken off, not taken off? How much is enforcement of arbitration awards? What are the challenges? This is what we would have Mr. Lalit Bhasin talk about. And the reason why Dr. Ramachandran is here, is also to share his perspective after the keynote of Mr. Lalit Bhasin on how it is impacting the infrastructure sector, how will these inefficiencies go away, how will silo busting happen, and what does he see as a role of arbitration in speeding up infrastructural projects. So with that, I would hand over to Mr. Lalit Bhasin. Lalitji, thank you for your services to the country and to the field of arbitration particularly. So we'd love to hear from you as to where arbitration is in India.
Thank you, Dr. Samir Kochar, Mr. Rohan Kochar, Dr. Gursharan Dhanjal, the Vice Chair of SKOCH Group, Mr. Ramachandran, and other distinguished participants. And last but not the least, thank you, Vrinda, for your very lavish introduction. SKOCH Group has done pioneering role in giving it back to the society. I've seen over the years, possibly decades, how Dr. Samir Kochar has been giving it back to the society after having achieved great and unique success in his business. He performed social responsibility, that is, commitment to the society, to perfection. Today's topic also speaks about his involvement in the causes which concern India, particularly the system of administration of justice. Although the topic is arbitration in India, but in my view, it encompasses, you see, the entire system of administration of justice, because arbitration has been considered as an alternative to dispute resolution. Therefore, one has to speak about the present state of affairs so far as our justice delivery system is concerned. Therefore, it is a very relevant, important, and timely subject. It is not just like any other topic on arbitration. These days, we have seminars and conferences galore on arbitration, whether it is successful, whether there should be institutional arbitration, ad hoc arbitration, whether it is effective as an alternate dispute resolution mechanism at all, and whether it is relevant or not. But the topic today is arbitration and India. Therefore, we have to see the relevance of arbitration so far as India is concerned. We had that 1940 Act earlier that pertained to arbitration of essentially commercial disputes and all that. And it is, this subject encompasses issues such as relevance for the common man, that is the ordinary citizen of this country, so far as arbitration is concerned. And that answer is clearly that it is not relevant, you see, for the common man, because he cannot take fruit of arbitration. Second issue, essentially for corporate disputes under the existing Act, 1996 Act. It has two parts. One is the domestic arbitration, other is the international arbitration. Therefore, the common man, the common citizen of this country is completely left out of the scope of arbitration. Third is less expensive. Certainly not. It is monopolized and capitalized, actually, whereas it should have been open, you see, to architects, to engineers, to bureaucrats, retired bureaucrats, and all those people to be a part of the system of administering arbitration. But that is not happening. And in the hands of the judges, it has become very, very expensive. And fourth issue is whether it is expeditious. Again, certainly not. Although the new law has brought in, you see, that, okay, you must complete it within 12 months. Okay, we give you another 6 months. But then you can always approach the court to get extension, you see, because the courts are really readily, they give extensions to the arbitrators. Does India need arbitration? Or in other words, is arbitration an appropriate mode of dispute resolution? Arbitration, is it only to resolve the commercial disputes? Certainly not. Any mode of alternate dispute resolution must take in the needs of the common man, the needs of the citizens of this country, which arbitration does not. So why do we keep on discussing about arbitration? The need of the hour is to discuss litigation where common citizens and chief ministers of various states, the high courts and the states, he said there are nearly 4 crore cases. I think he's wrong, because now the figure is up to 5 crore cases. 5 crore cases are pending, including Supreme Court, High Courts and District Courts. So what is being done? If we have to discuss about arbitration, first we must discuss about litigation, because in the administration, courts are also involved in the system of arbitration, whether it is a Section 9 application for interim relief, Section 11, Section 34 petitions, you see, to challenge the awards. Therefore, courts and arbitration procedures are intricate. Therefore, if there is a delay in disposal of cases in the courts, that would automatically impact, you see, the arbitration cases in India, particularly in India. Therefore, system of administration of justice can improve in India. Now, what are the causes and the remedies for this? That's interesting to know. The first is that we have too many laws, outdated laws. We have laws which were framed way back in 1876, 1896, 1920. All these laws are there. Too many laws, outdated laws, and there is no rationalization of the laws. In the same conference which was addressed by the Honorable Chief Justice of India and the Prime Minister, the Law Minister said that they are in the process of rationalizing the laws, and so many laws are being obliterated from the statute book. But at the drop of the hat, at the same time, we are bringing in new laws and new regulators, resulting, you see, in increase in litigation, increase in disputes. With every new law comes, you see, it is good for lawyers, but certainly not good for the economy of the country if you have too many laws. Another factor is poor infrastructure. That also the Chief Justice highlighted. And courts are working at half the strength. Has to take the call. The President of India has to issue the warrant of appointment. Therefore, some delay in the procedure for appointment. So we can reduce dependency of cases if government has to take a positive, constructive view. That very well, the government loses in the court of first instance. It's a very important question of law. They will not go in appeal. In almost 60, Justice made a very significant point that why can't you see these public sector undertakings, the ministries and all, they evolve a system that very well, let us avoid going to the courts. We can settle the matters. I remember when I was representing, you see, a public sector undertaking, there was a dispute construction with a construction contractor while constructing, you see, the Centaur Hotel in Bombay. So I told them, I said, you have a weak case, so why don't you try to settle it with the other side? They said, sir, we can't settle it. Because today, if we settle the matter, tomorrow there will be a CBI inquiry as to why you have settled the matter, why you have not allowed the court to proceed. If whatever the court says, we will pay. But we are not going to enter into any settlement with this. Now, this is the type of approach which the government officials and particularly those in the public sector undertaking, they have. So some soul searching has to be done by the ministry, by the government as to how dispute can be reduced. That is why when we talk of settlements as arbitration, the government has to take the lead. As I said earlier, Section 9, Section 11, Section 34, Section 37, everywhere the courts are involved. This stranglehold of the courts is there on arbitration, and that results not only in inordinate delays, but also in lot of expense. Because if some matter goes to the court, then court is not bound by that limit of 12 months or 18 months and all that. Court may take its own time to settle, to decide about the matter because it has to adjudicate upon it. And looking at the situation as it is, particularly in Delhi and Bombay and other high courts, it is impossible to get a positive award, to get an award which is enforceable from the arbitrators. So what is the remedy? The remedy is to go back to our ancient practices. Consensual form of justice. Our emphasis has to be on justice, because our constitution says that we, the citizens of India, give to ourselves this constitution which lays down that our citizens will get justice, social, economic, and political. That is in the preamble of the constitution. But in the body of the constitution, the word justice is consciously missing. Emphasis then turns to law. Who can make the laws? Center will make these laws. States will make these laws. There is a concurrent list. Emphasis shifts to law and the technicalities of law. Justice takes a back seat. Therefore, that is how this adversarial system of administration of justice came into this country, brought in by the British. Before that, we had the panchayat system here at the villages. All the differences used to be resolved. Then we had the Zilla Parishads at a higher level. All the dispute used to be settled. Even during the Mughal times, the Mughal kings believed in justice, what is called Adle Jahangir. Adl means the justice, Jahangir's justice. There were no laws, no technicalities. You used to stake what is just and proper. But we have now a system and we have to live with that, because there is our constitution which gives sanctity to the framework of our system of administration of justice, which is 3-4 tier, possibly 5 tiers, starting with the court of the sub-judge, it goes to the senior sub-judge, it goes to the district judge, it goes to the high court, it goes to the division bench, then it goes finally to Supreme Court. In Supreme Court rules, you also have a review, then you have curative petitions. All these are their adversarial system of law, little emphasis on justice. So in order to go back to our system and within the present framework which our constitution provides, there is still a way out. And that way out is mediation. Mediation is the answer, not arbitration. Settle your disputes. And I always tell my clients, and I've been doing so for the last 60 years, that a bad settlement is better than successful litigation. Therefore, mediation has to be promoted. That spirit of promoting settlement has to be inculcated, and that can be done. Our mindset has to change. And instead of bringing new laws, one should encourage, mediation. That is also self-regulation. Government should have confidence in the stakeholders, in the business leaders, that they can set up their own regulations and be governed by those. We have seen that in the Advertising Council of India, where all their internal disputes are settled and all that they are done. Therefore, even at the education level, university, law schools level, what has to be inculcated is a spirit of negotiations, negotiation skills. They have to be taught to the students of law, which would help them in then resolving their differences with the opposite parties in their business transaction, in the matters of interpretation of contracts, so that settlements could be successfully negotiated. Our court system has to be brought back on rails and mediation has to be promoted. That is my humble suggestion. And in order to bring back our court system, which is interconnected with arbitration, because eventually arbitration awards can be enforced if Section 34 applications, petitions, you see, they are decided. Therefore, in order to do that, the government should act, reduce the number of cases, don't bring in new laws just for the sake of it, remove all the obsolete laws, overlapping laws, outdated laws from the statute book. Let there be a rationalization, you see, in that. So that is my humble submission for your consideration. And I congratulate India Law Forum and the SKOCH Summit for giving me this opportunity of sharing my views with all of you. Thank you.
Excellent. So over to Dr. Ramachandran, sir. What are your takeaways and what are the questions that you have in your mind?
Thank you, Samir, and thank you, Mr. Lalit Bhasin. I think you have taken us all to a level where we go back to our ancient practices and try to resolve issues. You also referred to the problems which government officials face. If some sort of understanding is arrived at, then what it will lead to. So the question is, how do we find a resolution of this issue? Arbitration itself was supposed to be an approach where these things become easier. You refer to what happens at the village level and all that. In UP, I remember Nyaya Panchayat level used to work out solutions to disputes. Then the Jila Adalats, where they sit in public and work out solutions, that also used to be there. These are some are informal solutions, some are formalized solutions. But the number of arbitration cases seem to be really going up. And as you said, it is time consuming. So could there be, especially in the context of our infrastructure projects where we need to move fast, where we keep talking about time and cost overruns and things like that. And if there is a dispute, one has to essentially take it to a level where an authority outside the system gives a solution or a decision. So, I mean, short of going to the judiciary, this was supposed to be a mechanism. If this also is not delivering, can we have additional mechanisms which will give solutions, faster solutions? Can there be a provision for that? That is one point which could be thought of, because in a dispute, in a corporate dispute, or where there is a dispute between the contractor and a government entity or even private entities, I find they also have problems. They also take it to the arbitration level and go to the different levels which you referred to. So, especially talking about infrastructure, my question for your further suggestion, though you would have more or less covered it, would be, can we think in terms of mechanisms which are workable, which the authority of which would be accepted, which would be somewhat informal and which will deliver quicker resolution, and have larger number of them because we have such large number of projects and disputes coming up? Would something like that work in our scheme of things? Probably, if I want to articulate it a little further, I would talk about some of these mechanisms. Maybe there is a senior retired judge or so, senior advocate or so, or such functionaries who could become part of a scheme of things where the solutions could be worked out and that would be acceptable. Could that be one way out? Because amendments, the legal process, some of you have sat in the lawmaking house, Rajya Sabha also, but we still have these issues before us. Would something like that work, Mr. Bhasin?
Yeah, you see, it can work, provided that you have some experts as arbitrators. You know, as I said, it is monopolized by retired judges and lawyers. the arbitration process. We have to bring in architects, engineers, we have to bring in the company secretary, chartered accountant, business people, representatives of the chambers of commerce, and retired bureaucrats, you see, whose experience and knowledge can serve. But here it is only judges as if they know everything. My experience is that they hardly know anything about the intricacies, particularly about the type of disputes that you are referring to, construction, infrastructure. Yes, we know the law of contract, but we don't know the intricacies, the complexities which are involved in the transactions. You need expert people to do that. And in the absence of expert people, there is a, you see, risk factor which is very high of the award being challenged because they are not worded properly. There is no reasoning given. They only deal with the legal aspects without dealing with the factual aspects. Arbitration is a process where first the facts have to be gone into about breach of contract, who has committed, what were the commitments, what commitments have not been fulfilled. Therefore, all those have to be gone into first. But the approach, you see, by virtue of the training that we as lawyers get and judges get, we just try to go to the legal points. Legal points may not be relevant at all. It should be decided on the merits. Merits means on the facts.
That's a very interesting idea, Dr. Bhasin. Dr. Ramachandran, he said that it has to be, more factual than legal. And he's missing people like you from, arbitration process.
The question is, Samir, that also has to be given some sort of form and shape, otherwise it will not be acceptable. So, like you mentioned about the village process, arbitration itself was brought in, conciliation arbitration was brought in so that there is another recourse available and every matter does not get scaled up to the court levels, high court or Supreme Court levels. Now, can we have some sort of a recognized mechanism, because that would be relevant for the functionaries because they could say that we went to this forum for our resolution of our dispute, and also it should be acceptable to the public. And then would there still be an appeal process after that? That would still remain. And if it's a judiciary which goes into the decision process, they will say that all facts have not been considered, there are inconsistencies, and things like that. So that's one aspect. The other point I wanted to ask Dr. Bhasin was, you said it's better we go back to our ancient practices, but globally, are there some mechanisms which we can look at, which also could be thought of in the context of resolving our disputes, especially because whether it is a private party or a public sector or a government, they naturally have to go to the dispute forum and find a solution. So are there some practices which we can look at? And the related question would be, we have lived with this arbitration for quite some time. Has there been a review of the arbitration mechanism and what more can be done? Has that come out? Two questions, related questions, Dr. Bhasin.
Mr. Ramachandran, a very relevant question, then particularly in the global context that you were talking about. Now, I can tell you with my experience and with my participation in these some of the arbitration matters, disputes, that all the countries, various systems, they are moving towards mediation. Mediation is the answer that is recognized now by the International Bar Association, by the International Chambers of Commerce. They are all moving towards mediation. And fortunately in India, a move has been made now that a mediation bill has been introduced in the parliament. But that needs to be fine-tuned. Therefore, whatever perspective we want that those should be incorporated in the mediation, this is the time when we can tell, you see, the parliamentary committees and the ministries concerned, particularly the Ministry of Law and Ministry of Commerce, that these are the elements which are missing. Try to give some teeth, you see, to mediation. Make it enforceable in some manner or the other. because at the moment it lacks that. Mediation is voluntary. You may accept, you may not accept. But the new mediation bill, I think that is a very good initiative of Prime Minister Modi's government, because they recognize that mediation, and that is in line with what the other countries are thinking, because we participate in various international conferences. Therefore, emphasis is not much on arbitration these days. It is how to promote mediation. That is the way out.
So, Mr. Bhasin, I have a related question. Now, you said that, arbitration is supposed to be fact-based first, and then, you should not get into legalities of it to start with. Perhaps mediation would be more so. But the problem is that our recording of facts itself leaves a lot to be desired. We are still in the 19th century. A lot of things is paper-based. If you look at construction and infrastructure, a lot of 2D things we've been doing. Whereas globally, everything is now computer-based project management. So even if you, do a contract and then there are changes, as there would be, and then there are to-dos that land clearance kab denge, when will you give me an environment clearance? So there are two sides to a contract. Now that documentation of who failed where is very much possible using technology. The whole world does that now. You have things called building information management modeling, where if you do that and all your change orders, etc. is there. So it's like an online collaborative project management system which keeps track of everything. But I think in India that is not used because cost and time escalations are inbuilt in the contract, because everybody quotes below cost, and then there is the entire ecosystem in trust that how do we increase time, delay, and cost, therefore, to make the project viable. So what can be done? Do you say technology is an answer if that is forced?
Technology is definitely an answer so far as these technology-oriented contracts are concerned, particularly like the construction contracts, infrastructure contracts. They may not be relevant so far as the, say, hotel management contracts are concerned, or services sectors are concerned. They may not be relevant. But right, for manufacturing and infrastructure activities, technology can definitely play an important role, and technology is being applied overseas in the even in arbitration disputes. Evidence is led and expert evidence are produced, but that sort of a thing should happen in India. But the problem again is that our so-called arbitrators, they are very learned people, but they are not used to the latest technology. For instance, people like me, I'm 84 years, I'm not familiar with technology. If something goes wrong with my laptop and I am addressing you, I will call you, see my colleagues, oh, help me, you say to do, how to come back on the line. So we are not familiar. Therefore, some new thinking, new young blood has to come in to bring in the technology, new ideas, new mindsets. That is the answer. And one has to go into facts. Legal things will take care of themselves, you see.
Yeah, because you find that even expert evidence is based on opinion, not on facts.
That's right. Yes.
Because there are no facts. First you have to create the fact. Now, what is the fact? It doesn't exist. So just to prepare the file and back documentation and all that is an endless exercise. So I think technology has to be an integral part of contract and project management, specifically where hard goods like manufacturing, construction, infrastructure, clearances, etc. These are concerned. As you said, may not work so well with services industry, but in this infrastructure, construction, manufacturing, it has an invaluable role to play.
Because it is automatically documented, you see, in the computers and all that. So it is there, but what you need definitely are the trained mediators. If the first process is, matter should go to the mediation. Right. Therefore, you need trained mediators who inspire confidence in the parties, and they don't go into facts. They listen to the versions of the two parties, try to advise them what is right, what is wrong. And that is where the role of the organization like the Chartered Institute of Arbitrators and Mediators that comes in because they impart training not just to judges and lawyers, but to all the other experts like engineers, architects, company secretaries, chartered accountants, and all that.
Right, sir. Fascinating discussion. Ramachandran sir, last word to you.
One is, Samir, I hope you got this point. If there is a mediation legislation under consideration, there is some input which can be provided as a think tank. I think that's one point which is emerging out of this talk which Dr. Bhasin has given. If there is time, I just wanted to raise one more point with Dr. Bhasin. Drafting of contracts. Isn't there scope for improvement? And if that itself improves, aren't we reducing the scope for litigation? Is there some sort of a a community looking at it and trying to bring about improvements? Because normally what happens is my contract with an entity, I try to keep it as confidential as possible, rightly so, I would think. So is there potential for that as well, which could probably reduce litigation to some extent, where things become much more transparent and clear? Is that desirable, or it is not desired by the participants? Dr. Bhasin.
It's a very relevant thing. I will say that it does not need improvement so far as drafting of contract is concerned. There should be some unlearning so far as drafting is concerned, because we use very technical language, again inherited from the British. If you look at any act, or any contract, it will start with and whereas, subject to, without prejudice to, notwithstanding this, notwithstanding that. Now this, we have to unlearn this. We have to use simple English to explain, and possibly later on even in vernacular languages, Hindi and other languages. Simple language, what is the law or what is the contract? This is my obligation, that is your obligation. This is your entitlement, this is my entitlement. You don't have to make those 100 pages of contracts, you see, because contracts can be very simple, and we have tried that. In our Society of Indian Law Firms, we have introduced, you see, a course of use of simple English. It is Mr. Jyoti Sagar, one of the most eminent lawyers, head of the JSA Associates. He has brought out, you see, how we can use simple English to make it more accessible, knowledge-wise, for the common people. So that is the answer. We have to unlearn. There is no need to improve upon that contract, but to simplify the contracts. So you are absolutely right. Transparency can come in only if you have simple language, which is understood by everyone, not the technical language, which is understood only by judges and lawyers.
Yep. So, I think we have overshot by 15 minutes, and there have been a few audience questions as well. Let's take another 2 minutes, and let me ask you one question, which is, what are the ways that you suggest that India could improve on the enforcement mechanism, keeping the discussion in mind? Ways to improve enforcement mechanism. Dr. Bhasin.
Enforcement mechanism, you see, is not at all satisfactory, and particularly as far as the international contracts and international awards are concerned. But what in execution, there could be so many objections to the execution that the enforcement of the contract is considerably delayed. This is what we have to pay for. After you get a degree, it will take certain, because the execution, it will come up after 2-3 years for the hearing, and then we don't know how much time it will take. Therefore, it is like a lip service that we are doing, you see, okay. Enforcement is provided for, but certainly it can't be executed. So that brings us a bad name as a country also. and there is no answer.
Thank you very much. I guess now we need to close the discussion. However interesting it is now getting, there are lot many things that comes to one's mind, and thank you very much, Dr. Bhasin, for taking us through your experience, having learned quite a few things from your keynote, and we love to interact with you once all over again with another perspective, and would have you back on another platform. Dr. Ramachandran, thank you very
Have
much.
something on mediation, and also have something on the present system of administration of justice, whether it serves the common citizens, the common persons of India or not. Have something on these important topics. I thank you. I thank Mr. Ramachandran and of course Mr. Samir Kochar, Rohan, and Brinda, and to you.
Thank you very much.
Thank you very
Dr. Dhanchal, thank you.
I shall soon come and meet you and understand what can be done on mediation. And
Sure, sir. Thank you. Most welcome.
thank you so much.
Have a good one.